My name is Marck Joseph, and I'm a South Florida family law attorney. And you're here to learn 5 things you should know about timesharing/child custody in the state of Florida. Before we begin, I would like to define what timesharing is. In recent years, Florida statutorily has moved away from using the term child custody when describing the time a child or children spend with their parents to timesharing. The reason for this is the theory that both parents have equal rights to the children. With child custody, it is presumed that one parent lives with the child or children and the other parent just has a right of visitation. That is not the case. Both parents have rights to the child, and when the child or children are with each parent, they are timesharing, thus the term. Fathers in divorce actions have an automatic right to timesharing with their child or children, while fathers in paternity actions do not. The reason for this is the court's natural guardian statute, which states that fathers of unwed children do not have any rights to the children until they have established their paternity, and that the mother is the natural guardian of the children and has all those rights individually. While a party going through divorce, both parents have already their rights established, and therefore the right to have time with the children is inherent in the fact that they were married when the children were born. Although archaic, this is the law as it is today. In the state of Florida, neither parent is presumed to be more equipped to care for the child over the other. In the state of Florida, there is no presumption that the mother or the father is a better parent, so to speak. There is multiple factors that is considered when the courts are to consider what the timesharing is supposed to be for the child or children. After going through all these factors is when the court will determine what it will be the timesharing schedule of the parents. However, to be clear, state of Florida does not acknowledge that a mother is a better parent than the father, nor is there a presumption of the otherwise. Both parents sit on equal footing until these factors are considered by the court. Timesharing can be done with an agreement by the parents. However, if the situation is contentious, you want a court order. The reason for this is that when both parents are getting along, it's good to know, and the court encourages, that they co-parent, which is make decisions in regards to the children and work together raising the children. However, if you're unfortunately in a contentious situation, the one parent or the other tend to begin to start using the children as a bartering tool, in which the time with either parent gets significantly reduced when one parent isn't happy. Although this shouldn't happen, it does. If this situation occurs, it's typically good to have a court order in place in which the court had made these decisions. And if another parent attempts to overwrite another parent's rights to the children, that they can be held in contempt. This is not to say that you guys can't agree amongst yourselves and then bring that agreement to court in which the court ratifies. That way, you guys can still work together to come with an agreement, and you still have the enforcement ability of that agreement by the courts. There is no presumption as to what the timesharing schedule should be between the parents. What I mean by this is that there is no formula written into the statute that presumes that either parent should have a simple system or time with the child. There's no presumption that the father should only have every other weekend or maybe some summertime, or that the mother should have the weekdays and the father should have the weekends or anything. Substantial timesharing from either party activates gross up. What gross up is is the theory that once a parent has a substantial amount of time with the children, in the state of Florida, 73 overnights or more, it creates a reduction in the child support obligation. I go into child support much more in one of my previous videos. We've left the link below. I suggest you watch it to understand how time sharing applies to that. That being said, the more time both parents spend with the child, the less the child support obligation becomes. So I would suggest that you have a consultation with an attorney if this is something that you're concerned about, so you can discuss how your particular set of circumstances may be affected by this gross up calculation. So if you or someone you know has an issue with time sharing in the state of Florida, contact my office and schedule a consultation, and we can let you know how we can help you. And if you enjoyed our video, like it. And please take a look at some of my other videos and subscribe below. Thank you.